Now, damages. One of the things we do, and I blame this on the law schools because the law schools don't really teach us about damages. I taught damages in law school for 25 years, and they really don't teach us about how to prove damages, about how to examine every element of damage. So what you want to do is create a body of evidence with respect to each element of damage separately. And I've been doing this. I worked this out over 25 years of teaching it, and now 50 years of actually doing it. So when I talk about this, we want to look at every element of damage there is. But the first thing you do is we have a checklist where we check off every element of damage. We have a checklist for personal injury litigation. And so if it's a personal injury case, we go down and check it and make sure we've pled every possible element. But this whole thing about creating a body of proof, physical pain and suffering is one element of damage. Mental anguish is a different element of damage. You need to think in terms of creating a full body of proof just for physical pain and suffering. And by a full body of proof, you look at we'll get in our war room and put physical pain and suffering on the blackboard. And then we'll look at the witnesses. What is the expert testimony we have on this? What is the lay testimony we have on this? What is the documentary evidence? What is the demonstrative evidence? And what do we have from pretrial discovery that will help us to prove the elements of physical pain and suffering? And when you list all the witnesses who can prove physical pain and suffering for you, then you match them up and you sequence them and you find the documents that will support each one of those people in proving physical pain and suffering. When you get all your physical pain proof together, that's one body of proof. Now you move on to your next element of proof, which is mental anguish. Mental anguish is not the same thing as physical pain. There's so many different variations of what constitutes mental anguish. For me, watching the Republican debate is mental anguish. I mean, that's, as an American, as a Democrat, it's hilarious. It's the best show on TV. But mental anguish has so many different aspects. So you look at every possible aspect of mental anguish at every stage. And I have a paper on that about the sequential approach to it, looking at it at every phase. But you build a complete body of proof on mental anguish. Then you look at physical disfigurement, if it applies, physical impairment, which is also physical disability. You look at bystander mental anguish. You look at loss of society and companionship, loss of consortium, loss of household services, the value of nursing services. You look at every case. Does this element of damage apply to this case in any way? You look at loss of earning capacity, and then the difference between wage loss and wage earning capacity. And the fact that, what do you do about the fact that your client is now back at work making more money than they were making before? They're on a different job, but they're making more money than they're making before. That doesn't preclude you recovering for a loss of earning capacity, because if they can no longer do the job they could do before, they've lost their capacity to earn money in that line of work, and so you have damage to wage earning capacity. Then you look at medical expenses. One of the things you look at, pharmaceuticals, lifetime pharmaceuticals. You take one drug, you take 3 or 4 different pills that people are having to take now for their pain, for their muscle relaxers, whatever, and whatever they're taking as a result of this. It doesn't sound like very much in terms of damages, but if you have a permanent injury, you take that and you give it to your life care planner, and you spread that out over a lifetime, over the life expectancy of your plaintiff. You'd be astonished. And at the normal increases they calculate the normal increases in cost. They calculate one little thing like pills, and it becomes thousands and thousands of dollars. But not only does it become thousands and thousands of dollars, it raises the point that this plaintiff is going to have to be taking these pain relievers or muscle relaxers or whatever for the rest of their life as a result of this, as a result of the actions of this defendant. So it just stresses the permanent nature of the injury. Funeral expenses. I have I had a young lawyer that was working for me, brand new, just hired him out of law school, and I taught him in law school. And I always taught them, go ahead and plead your damages. Be sure and plead all your damages, because if you plead them and you can't prove them, no harm, no foul if they're in your pleading. But if you try to prove them and you didn't include them in your pleading, then you can be, you may have to try to get a trial amendment or whatever. So he came in, one of my associates came in, and he said, you know, he really took you at heart about this. He said, you need to read this part on funeral expenses. And he had pled, the decedent has experienced funeral expenses in the past, and in all reasonable probability will experience funeral expenses for an indefinite period of time in the future. And so I called him in. I said, what are we dealing with here, the eternal flame? And he said, no, the suit was rented. So, but what the hell, take a shot. Then you want to get into personal property damage, cost of vehicle repair, whatever. Recoverable elements, pre-impact terror. You have to think about that. The people who are looking, I had a case in which this couple is sitting there, and there's a 18-wheeler bearing down on them, and there's absolutely, he sees it in the rearview mirror, and he screams out, and the wife turns around and looks, and they see an 18-wheeler bearing down on them. They're on a bridge, they can't go this way. Solid traffic stopped. All traffic is stopped. They can't go forward, they can't go this way, they can't go this way, and here's an 18-wheeler bearing down on them. Okay, it's a few seconds, but it's pre-impact terror. But that's a classic example. That's of the mental anguish in pre-impact terror. The jury awarded $5 million in the pre-impact terror for the 7 minutes between the problem with the airplane and the fact that it took them 7 minutes to glide down to a crash, and they award $5 million for pre-impact terror for living through that 5 minutes of knowing you're going to die. So you have to think about things like loss of chance of survival. So some states have that, others don't. Attorney's fees, there's so many places where there are provisions for attorney's fees in statutes that lawyers never think about applying for. It's just amazing. Statutory penalties, statutory damages, DTPA, treble damages for consumer protection, contractual damages, bad faith damages, pre- and post-judgment interest, and punitive damages. Now, in the last few minutes, I'll tell you about how do you handle how do you determine how your millennials think differently than your other boomers and your Gen X. And here's how you find out. It's through focus groups. You want to think about how they think about your specific case. So we go into demographics. You do focus groups within cohorts. And a cohort means Generation X, the millennials, their generational cohort. So if you want to think about it, there are a couple of ways to do it. One is you bring in just a group of millennials. We do this all the time. You bring in a focus group of nothing but millennials. So you bring in 12 or 18, whatever you're working with, and then you give them the facts of your case, and then you listen to how they talk about it. You listen to the metaphors they use, the analogies they use, the language. How do they describe the things in your case, and what is their language of the case? And you'll find that a lot of times how they describe the case, their language of the case is going to be different from how the boomers. Then you do a focus group with nothing but boomers. You do a focus group with nothing but Generation X. And then compare, and you obviously video these, and then compare these, and listen to the rhetorical devices the metaphors, the analogies. You have different metaphors will resonate with the boomers than will resonate with the millennials. So you test those, and you actually you can test your metaphors, which are powerful, powerful persuasion tools. And you give them a situation and say, okay, I want you to write the rest of the sentence. And you give them a situation and say, this situation is just like what? And let them fill it out. Whatever they put in there is a metaphor. And you'll find that they have different metaphors than the other generations. You want to do show and tell. You want to test your demonstratives so that you can learn. The idea is to learn to tell your story across demographic lines. You're trying to develop a story that will resonate with all your generations. So you make a simple, non-persuasive, vanilla presentation, and then there's another way to do it, which is you can take 18 panel jury or 21 panel jury, and you make the same vanilla presentation to all of them, no difference, and then you divide them up. You've got 7 millennials, you've got 7 Gen Xers, and you got 7 boomers. Now you divide them up into 3 different groups and give them the same questions or the same basis for discussion, and then you listen to how they discuss, having heard exactly the same data, how did the 3 different groups discuss this differently? And then how do they discuss it the same? Because when you hit those points about how they discuss it the same metaphor that resonates with all 3 groups, the same demonstrative resonates with all 3 groups. Now you're talking about something you're using in your trial that resonates with everybody. So you videotape them, and then you let them deliberate on their own. You give them written questionnaires. You video all proceedings. Your large group, that's what I was just describing. You're looking for language of the case, metaphors, and a rule of 3 quiz. At the end of it, I'll say, okay, write down the 3 things, the 3 pieces of evidence that were most important to you. This is after they deliberate and arrive at a decision. Then you write down the 3 pieces of evidence that you thought were most important in the case. Do that with all 3 generations and see what differences you get. What were the 3 most important elements of damage that you heard? What were the 3 things that caused you to, what were the 3 most important things you heard on liability? And then you ask them about you test your metaphors on them. You test your graphics, you put your demonstrative. I never ever showed a demonstrative to a jury without having tested it with focus groups. You test your graphics, you test your timelines, you test your rules, see who resonates to the rules. And then you test your medical protocols, and then you put it all together, come back with different focus group, and test your cross-generational storytelling, test your case-specific facts, and test responsive to each elements of damage and how they responded to by each different group. That's absolutely everything I know about generation X, Y, and damages. I hope I've said something that will help you, help your clients. Thank you very much.